Good evening and welcome to ASMR-E. Tonight I'm really excited because I'm going to share with you one of my secrets for falling asleep. My dear husband has tried to read to me his Tort Law book, and every time I end up falling asleep. So I thought I'd read a little bit for you tonight, and I'm confident that you will have no trouble falling asleep. So don't forget to bookmark this video in case you're ever dealing with insomnia or restlessness and you just need to fall asleep. Well, I've randomly chosen this case called the Boyer v. Iowa High School Athletic Association, and it's from 1967, and we have this well-loved printed copy of this book, so don't mind all of the highlighting and notes. Okay. Boyer v. Iowa High School Athletic Association, 260 Iowa, 1061152 NW 2nd, 2D 293, 1967. Garfield C.J., the plaintiff, a spectator at a basketball game under the management of the defendant, was injured when the bleachers in which she sat collapsed. The bleachers were designed to fold against the gymnasium wall when not in use. As the game ended and the spectators began to leave, the section occupied by the plaintiff and others suddenly folded back towards the wall, throwing the plaintiff to the floor 9 feet below. After verdict and judgment for plaintiff, the defendant appealed. 1. Plaintiff pleaded her case in 2 counts or divisions, one charging specific acts of negligence, the other in reliance on the doctrine of res ipsa loquitur. We have frequently held this is permissible, provided, of course, the doctrine is properly applicable. The trial court ruled there was no evidence to support the charges of specific negligence and withdrew them from jury consideration. The case was submitted to the jury on the doctrine of res ipsa loquitur. Two, defendant first assigns error in the court's refusal to withdraw from the jury the division based on res ipsa loquitur. Quote, under the doctrine referred to, where injury occurs by an instrumentality under the exclusive control and management of defendant, and the occurrence is such as in the ordinary course of things would not happen if reasonable care had been used. The happening of the injury permits but does not compel an inference that defendant was negligent. Schenofield v. Curtis, 25 Iowa 1352 136066 NW2D 465 470 50 ALR2D 964 and citations. Quote, in considering the applicability of res ipsa loquitur, the question whether the particular occurrence is such as would not happen if reasonable care had been used rests on common experience and not at all on evidence in the particular case that tends in itself to show such occurrence was in fact the result of negligence. Schoenfield v. Curtis, Supra. Smith v. Olerick, 259, Iowa, 797 804 145 NW 2D 15. Thus, the two foundation facts for application of the res ispa doctrine, which permits an inference to defendant's negligence from happening of the injury, are 1. Exclusive control and management by defendant of the instrumentality which causes the injury, and 2. The occurrence is such as in the ordinary course of things would not happen if reasonable care had been used. We think the injury could properly find these foundation facts existed and infer therefrom plaintiff's injury was caused by defendant's negligence. Bleachers designed for use by spectators at athletic events do not ordinarily collapse when used as they normally are, without negligence of those having control and management thereof. Defendant asserts the res ispa doctrine does not apply, first because it is said the evidence of the cause of the collapse was accessible to plaintiff and not particularly accessible to defendant. As plaintiff admits in argument under our decisions, the underlying reason for the res ispa rule is that the chief evidence of the true cause of the injury is particularly accessible to defendant, but inaccessible to the injured person. In these precedents, one or both of the foundation facts above referred to were lacking, and the absence of what we have said is the underlying reason for the rule was given as an added reason why it was not applicable to the particular case. We have never held presence of this underlying reason is an indispensable requirement for application of the doctrine, nor are we persuaded evidence of the true cause of the collapse or partial collapse of the bleachers was not particularly accessible to defendant rather than to plaintiff. The athletic director of the Mason City Schools was acting manager of the tournament. He and the head custodian at Roosevelt Junior High School must be deemed under the contract between the school and defendant to have been acting under the management, supervision, and direction of defendant. They had the exclusive control and management of the bleachers at least until game time, and had the best opportunity to then discover any defect in them which may have caused the collapse. We are told plaintiff had as much access to the bleachers immediately after the accident as defendant did and could discover any defect in them. A seriously injured person could hardly be expected to then examine the bleachers for defect rather than to be concerned with proper treatment of her injuries. The argument, the only permissible conclusion to be drawn from the evidence is that the movement of the spectators at the end of the game caused the bleachers to collapse. The argument, the only permissible conclusion to be drawn from the evidence is that the movement of the spectators at the end of the game caused the bleachers to collapse cannot be accepted. Such a conclusion would rest wholly on speculation or conjecture. There is no evidence to support it. Assuming but not deciding, this would be a defense to the res ispa doctrine. It was defendant's burden to rebut the inference of negligence. Such limited control of the bleachers as plaintiff and other spectators may have had during and immediately following the game did not, as a matter of law, render the doctrine of res ispa loquitur inapplicable. The injury could find defendant and its agents were in control of the bleachers at the time of the negligent act as failure to inspect, which subsequently resulted in injury to plaintiff, and that she and other spectators did nothing improper or unusual during their occupancy of them, and find no reversible error in any respect assigned and argued, affirmed. The concurring opinion of Becker J. is omitted. One source of confusion in the application of res ispa is the requirement that the event be of a kind which ordinarily does not occur in the absence of negligence. 3 to 8d. If this phrase is interpreted as meaning an event which is more likely than not the result of negligence, the res ispa loquitur doctrine constitutes a rule of circumstantial proof based upon probabilities. If the phrase is interpreted more broadly to impose a liability for unfavorable negative outcomes simply because they rarely occur in the absence of negligence, however, the res ispa doctrine can reach unusual and probably improper results. Assume, for example, that an unfavorable event occurs on the average of once in every 100 times that an activity is engaged in with reasonable care. Assume further that a particular actor is, on the average, negligent once in 200 times, resulting in the same unfavorable event. On these assumptions, if the actor engages in the activity 1,000 times, the unfavorable event can be expected to occur approximately 15 times, 10 times in spite of due care on the part of the actor, and 5 times on the actor's negligence. If all that is known is that the unfavorable event has occurred, the probabilities are 2 to 1 against the event being the result of negligence. And yet, the traditional formulation of the res ispa loquitur rule that speaks of events that ordinarily do not occur when care is taken might support liability because of the remoteness, 1 in 100, of the occurrence of the unfavorable event, even when the actor uses due care. That is, the unfavorable event does not ordinarily happen when the actor is exercising care, in the sense that it only happens 1% of the time. The implications of this sort of misapplication of res ispa loquitur are explored in David K. Probability Theory Meets Res ispa loquitur, 77 Mich. L. Rev. 1456, 1979. A misapplication of this sort may have occurred in Younger v. Webster, 510 P2D 1182, Wash CT App 1973, in which the plaintiff, following an injection of spinal anesthesia, permanently lost all feeling from his navel to his knees. Medical testimony was unanimous to the effect that this consequence was unusual, but there was no evidence that when it did occur, it was usually produced by negligence. The court ruled that on this evidence, res ispa loquitur was applicable and reversed the trial judge's dismissal of the action at the end of the plaintiff's evidence. In so doing, the court stated ID at 94510, P2D at 1186. The present case comes within the reason and spirit of the doctrine. The present case comes within the reason and spirit of the doctrine. It is difficult to justifiably disregard the application of the doctrine when a patient submits himself to the care and custody of medical personnel, is rendered unconscious, and receives some injury from instrumentalities used in his treatment. Without the aid of the doctrine, a patient who receives permanent injuries of a serious character, apparently the result of someone's negligence, would be unable to recover unless the doctors and nurses voluntarily chose to disclose the facts establishing liability. CF Ybarra v. Spangard P. 121 above. In States v. Lourdes Hospital, 762 NYS 2D1, 2003, the Court of Appeals of New York determined that a medical malpractice plaintiff could rely on expert testimony to establish the predicate condition that an injury was unlikely to occur in the absence of medical negligence. 762 NYS 2D at 4. Expert testimony may properly be used to help the jury bridge the gap between its own common knowledge, which does not encompass the specialized knowledge and experience necessary to reach a conclusion that the occurrence would not normally take place in the absence of negligence, and the common knowledge of physicians, which does. Our conclusion not only is supported by a majority of courts that have considered the question, but also is the approach adopted by the restatement of torts. In an increasingly sophisticated and specialized society such as ours, it is not at all surprising that matters entirely foreign to the general population are commonplace within a particular profession or specially trained segment of society. Notwithstanding the availability of expert testimony to aid a jury in determining whether an event would normally occur in the absence of negligence, expert opinion, of course, does not negate the jury's ultimate responsibility as finder of facts to draw that necessary conclusion. The purpose of expert opinion in this context is to educate the jury, enlarging its understanding of the facts, issues it must decide. However, the jury remains free to determine whether its newly enlarged understanding supports the conclusion it is asked to accept. Tubbs v. Argus, 140 Ind App 695225 NE2D 841, 1967. FAF J. This appeal arises as a result of demurrer to applicant's second amended complaint, which was sustained, and judgment entered thereon upon the failure and refusal of the appellant to plead over. The facts material to a determination of the issues raised on this appeal may be summarized as follows. The appellant was riding as a guest passenger in the right front seat of an automobile owned and operated by the appellee when it was driven over the south curb of West Hampton Drive and into a tree. resulting in injury to the appellant. After the said collision, the appellee abandoned the automobile and did not render reasonable aid and assistance to the injured appellant. Appellant alleges that she suffered additional injuries as a result of the appellee's failure to render reasonable aid and assistance, and seeks to recover only for these additional injuries. In her assignment of errors, the appellant avers that the trial court erred in sustaining the demurrer to appellant's second amended complaint. More specifically, the appellant alleges that the appellee's failure to render reasonable aid and assistance constituted a breach of common law duty. The appellant herein is seeking recovery for additional injuries arising from the appellee's failure to render reasonable aid and assistance, and not for the initial injuries which resulted from the operation of the automobile, since she was precluded from recovering for ordinary negligence under Indiana's automobile guest law. At common law, there is no general duty to aid a person who is in peril. L.S. Ayres and Company v. Hicks, 1941, 220 Ind. 8640 NE2D 334. However, in the L.S. Ayres and Company, Supra, page 94, 40 NE2D, page 337, the Supreme Court of Indiana held that under some circumstances, moral and humanitarian considerations may require one to render assistance to another who has been injured, even though the injury was not due to negligence on his part, and may have been caused by the negligence of the injured person. Failure to render assistance in such a situation may constitute actionable negligence if the injury is aggravated through lack of due care. Tippe Canoe Loan, etc. Co. v. Cleveland Act R. Co. 1915 57 Ind. App 644-104 NE 866-106 NE 739. In Tippecanoe Loan Act Co. v. Cleveland Act R. Co. Supra, this court held that a railroad company was liable for failing to provide medical assistance to an employee who was injured through no fault of the railroad company, but who was rendered helpless, and by reason of which the employee's injuries were aggravated. The Supreme Court of Indiana, in L.S. Ayres Supra, found the appellant liable for aggravation of injuries when it failed to extricate the appellee, a 6-year-old boy whose fingers were caught in the moving parts of an escalator, even though the injury conclusively established that the appellant was not negligent with respect to the choice, construction, or manner of operating the elevator. In so holding, the Supreme Court stated that it may be deduced from Tippecanoe Loan Act Co. v. Cleveland Act R. Co. Supra, quote, that there may be a legal obligation to take positive or affirmative steps to effect the rescue of a person who is helpless in a situation of peril, when the one proceeded against is a master or an inventor or when the injury resulted from use of an instrumentality under the control of the defendant. The doctrine of law, as set forth in Restatement Second of Torts 322 p. 133, adds credence to these two Indiana cases. Quote, if the actor knows or has reason to know that by his conduct, whether tortious or innocent, he has caused such bodily harm to another as to make him helpless and in danger of future harm, the actor is under a duty to exercise reasonable care to prevent such further harm. In the case at bar, the appellant received her injuries from an instrumentality under the control of the appellee. Under the rule stated above and on the authority of the cases cited, this was a sufficient relationship to impose a duty to render reasonable aid and assistance, a duty for the breach of which the appellee is liable for the additional injuries suffered. We are of the opinion that the court below erred in sustaining the demurrer to appellant's Second Amendment complaint. This cause is reversed and remanded for proceedings not inconsistent with this opinion. Judgment reversed. Burley and Smith J.J. concur. Okay, well, if you're not already asleep, then I invite you to hit the like button and to subscribe to my channel, because I look forward to the next time when I can read the Tort Law with you, or to do any of the calming and relaxing activities that we all enjoy. I hope you have a good